Since 1976, the United States has executed over 1,600 people. Yet in that same period, more than 190 individuals on death row were later exonerated, meaning the government came within a legal hair's breadth of killing people who were completely innocent. That number should stop you cold. Welcome to Legal Eagle Brief. Today we are pulling back the curtain on one of the most debated, most contested, and most misunderstood institutions in American legal history, the death penalty. This is not a simple story of crime and punishment. It is a story of evolving law, racial disparity, constitutional conflict, and a nation that has never quite made up its mind. We will walk through where capital punishment came from, how the Supreme Court nearly abolished it, why it came back, and what the data actually tells us about how it is applied today. And there is one chapter in this history that most people have never heard, one that fundamentally changed everything and almost never gets discussed in high school civics class. To understand where we are, you have to go back to the very beginning. Capital punishment in America did not originate with the founders. It arrived on these shores from England, where the death penalty covered a staggering range of offenses. In colonial America, you could be executed for murder, but also for theft, witchcraft, adultery, and even heresy. The first recorded execution in colonial America took place in 1608 in Jamestown, Virginia, when Captain George Kendall was put to death for spying for Spain. From that point forward, execution became a fixture of colonial justice. By the time the Constitution was ratified in 1788, capital punishment was universally accepted across all 13 original states. The Fifth Amendment itself implicitly acknowledged its existence, stating that no person shall be deprived of life without due process of law, meaning deprivation of life with due process was legally permissible. The Eighth Amendment banned cruel and unusual punishment, but at that time, hanging was considered neither cruel nor unusual. It was simply the standard method. The 19th century brought the first serious reform movements. Pennsylvania became the first state to limit the death penalty exclusively to first-degree murder in 1794. Michigan abolished capital punishment entirely in 1846, becoming the first English-speaking government in the world to do so. Rhode Island and Wisconsin followed. These were not radical fringe movements, they reflected a genuine philosophical debate about whether the state had the moral authority to take a human life as punishment. That debate has never stopped. But here is what nobody talks about. For most of American history, executions were not federal events. They were local, sometimes public, and deeply embedded in community culture. Public hangings drew crowds. Newspapers covered them like spectacles. It was not until the mid-20th century that executions moved behind prison walls entirely, and it was not until 1936 that the last major public execution took place in Owensboro, Kentucky, when Rainey Bethea was hanged before a crowd estimated at 10,000 people. The shift to private execution changed the psychology of capital punishment in America permanently. Through the early 20th century, new methods replaced hanging. The electric chair was introduced in New York in 1890, promoted as more humane. Gas chambers followed in Nevada in 1924. The federal government carried out its own executions, including the controversial 1953 execution of Julius and Ethel Rosenberg for espionage. But the legal framework surrounding the death penalty remained largely unchallenged at the constitutional level until the 1960s. That is when everything changed. The civil rights movement forced America to look directly at who was actually being executed. The statistics were devastating. Black defendants were being sentenced to death at dramatically higher rates than white defendants for comparable crimes. In southern states, the disparity was most extreme in rape cases. Between 1930 and 1967, 455 men were executed for rape in the United States. Of those, 405 were black. That is 89%. The legal challenges that followed were inevitable. In 1972, the Supreme Court issued one of the most extraordinary decisions in its history. In Furman v. Georgia, the court struck down the death penalty as it was then being applied. The vote was 5-4. What made the decision remarkable was that all 9 justices wrote separate opinions, a rare occurrence. The majority found that the arbitrary and inconsistent application of capital punishment constituted cruel and unusual punishment under the Eighth Amendment. Justice Potter Stewart wrote that death sentences were being imposed so freakishly and so randomly that they were comparable to being struck by lightning. Overnight, the death sentences of over 600 inmates on death rows across America were commuted. But here is where it gets more complicated. Furman did not abolish the death penalty. It invalidated existing statutes because of how they were being applied. The court essentially handed legislatures a roadmap: if you want capital punishment to survive, you need to fix the process. 35 states went back and rewrote their laws. They created bifurcated trials, separating the guilt phase from the sentencing phase. They established aggravating and mitigating factors that juries had to consider. They built in automatic appeals. In 1976, the Supreme Court reviewed these new statutes in Gregg v. Georgia and ruled 7-2 that the death penalty, properly administered, did not violate the Constitution. Capital punishment was back. Gary Gilmore was executed by firing squad in Utah on January 17, 1977, becoming the first person executed in the United States in nearly a decade. The modern era of the death penalty had begun. What does the data from that modern era actually show? Between 1977 and today, over 1,600 executions have been carried out. Texas alone accounts for more than 570 of them, nearly one-third of the national total. The methods have shifted from electrocution and gas toward lethal injection, which became standard after Oklahoma adopted it in 1977 and was validated by the Supreme Court in Bays v. Rees in 2008. But lethal injection has generated its own controversy, as botched executions raised fresh questions about whether the method itself constitutes cruel and unusual punishment. The racial disparity documented before Furman did not disappear after the new statutes were put in place. A landmark study known as the Baldus Study, presented to the Supreme Court in McCleskey v. Kemp in 1987, analyzed over 2,000 murder cases in Georgia and found that defendants whose victims were white were 4 times more likely to receive the death penalty than those whose victims were black. The court acknowledged the statistical evidence but ruled 5-4 that statistical disparity alone was insufficient to prove unconstitutional discrimination in an individual case. Justice William Brennan dissented powerfully, calling it a tolerance of a racially discriminatory application of criminal law. The court has continued to chip away at the scope of capital punishment through targeted rulings. In 2002, Adkins v. Virginia held that executing individuals with intellectual disabilities violates the Eighth Amendment. In 2005, Roper v. Simmons extended that protection to juvenile offenders, anyone who committed their crime under the age of 18. In 2008, Kennedy v. Louisiana ruled that capital punishment for crimes other than murder, including child rape, was unconstitutional. Each decision narrowed the category of cases where death was a permissible sentence. Today, 27 states retain the death penalty while 23 have abolished it. Several states with active statutes have imposed moratoriums. Public support for capital punishment, which peaked at 80% in 1994, has dropped to roughly 55% according to recent Gallup polling. The number of new death sentences handed down each year has fallen dramatically, from over 300 annually in the mid-1990s to fewer than 25 in recent years. Federal executions, which were halted for nearly 2 decades, were briefly resumed in 2020 under the Trump administration, then paused again under the Biden administration. The federal government's own relationship with capital punishment remains unresolved. The story of the death penalty in America is ultimately a story about what a society believes the law is for. Is it about retribution? Deterrence? Incapacitation? The evidence on deterrence is inconclusive at best. The risk of executing the innocent is provably real. The application has never been truly consistent or race-neutral. And the legal architecture continues to evolve with every new Supreme Court term. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.